A very good morning to all of you. I am Somya Priyadarshni. I'm a senior associate with MRP Advisory. On behalf of Mayan, I welcome all the participants as well as our esteemed panelists who have invested their valuable time on this busy morning. I will be the moderator for this session. Before diving deep into the discussion, I would like to inform the participants about a few points. This session is being recorded and the video will be available to the site through which the registration was done. There will be a Q&A session towards the end, and there you can ask your questions in the chat box. There is a poll question which will be coming to your screen very soon. Please respond to this simple question and we will get back to you. The topic for this session is quantification of claims and counterclaims in construction contracts. Claims in construction projects are measured by many project participants to be one of the most worrying and unpleasant events of a project. Given the high competition, the contractors are forced to submit projects with minimum profits in order to be in the business. In addition to their multi-party nature, projects are becoming extremely complex and risky. This has placed an added burden on the contractors to construct sophisticated and risky projects with less resources and profits. Under these circumstances, it is not shocking that the number of claims within the construction industry continues to increase. Now, with this background, I'm introducing the amazing panelists of this session, who are the legal and technical experts in the construction field. Let us try to discuss these quantification issues with them from all possible angles. Our first panelist is Mr. David Brynmor Thomas. He's a QC with the 39 assets. He's a globally recognized specialist in the conduct of complex, high-value international commercial litigation and arbitration. Who's Who Legal considers him as one of the thought leaders in arbitration, and he has extensive experience in handling disputes arising from long-term commercial relationships and construction projects from across a range of industries. Our next panelist is Mr. Yogesh Gupta. He's a senior DGM legal with Larsen & Toubro. Mr. Yogesh has over 21 years of experience in a wide spectrum of practice areas, including in core infrastructure sector practice, construction disputes, dispute resolution, arbitration matters, civil commercial litigation, banking, and finance transactions. He has handled few infrastructure projects, advising both the government agencies as well as the private developers and contractors. Our next panelist is Mr. Kirindeep Singh. He is a senior partner in litigation and arbitration practice with Dentons, Singapore. His practice areas are construction and engineering, arbitration, general civil and commercial litigation, anti-bribery, and anti-corruption matters. He has been involved in numerous disputes before the dispute adjudication boards, arbitration and litigation, both as a counsel, adjudicator, and an arbitrator. Our next panelist is Mr. Mayank Thakur. He's a partner with Mayan. Mr. Mayank is a professional with 17 plus years of experience in claims and disputes, contract management, and project controls. He is a specialized relay and quantum expert for engineering and construction disputes and claims. He has served as a claims analyst on numerous projects and has testified before various arbitral tribunals. And lastly, myself, my name is Somya. As I already mentioned, I'm a dual qualified lawyer, licensed to practice in India and New York. My experience includes handling construction and infrastructure projects. I welcome all the panelists of the session. Now let's start the discussion. My first question would be for Mr. Yogesh. So you are from the construction industry and represent one of India's most reputed construction giant, L&T. In your experience as a part of this industry, what are the typical claims that are raised in a project?
So I would say, as far as the construction, arbitration, and construction projects are concerned, the type of claim which is raised in the arbitration related to construction sector would entirely depend on the what is the type and structure of the contract. So typically a claim in the concession agreement kind of a format can be very much different from the claims in the EPC contract or or in a contract where the BOQ based contract is there, or there can be a design build kind of a contract. And depending upon the terms and condition of the contract, the format of contract, claims can be a different kind of claim everywhere. So every contract has its own dynamics, and it depends that what is the structure of your transactions, the structure of your contract, which will actually define that what are the type of claims it can be. So for example, for in a concession agreement where the parties the private party, there is a it's a it's a collaboration between the generally a concession agreement as a collaboration between the government entity and a private participant, and the private participant being the concessioner is supposed to fund the project as well as he has to earn from the project, and he has to fund the construction also. And over a period of a concession period, he's supposed to earn his profits and earn his value. So generally, in those kind of contract, if a dispute arises, apart from the claims which can be in the form of extension of time for the concession period, the claims can be invariably for the change in scope. Sometimes the claims in relation to EPC contractors claims can also be part of that. Escalation in cost can be there. Then apart from that, there can be claims for the SPV or concessioners overheads, extended maintenance cost, loss of revenue, underutilization, loss of opportunity, reimbursement of the payment made to independent engineer during the extended period of the construction period, because generally typically in a concession agreement there is a construction period and an operation and maintenance period. So if the construction period get extended, then there is a extended deployment of the independent engineer, which is supposed to be paid by the concessioner as well as the government. So in case because of the government's default, the construction period get extended, then the concessioner can also ask for, within its claim, it can also ask for claim for reimbursement for the payments made to the concession for the independent engineer. Then apart from that, typically there are change in scope and change in law related claims are there, loss of profit, loss of revenues are there. And in certain cases there can also be claims for damages. On the other hand, in case it is a BOQ based contract, or it is a EPC contract or design or build contract, in that case generally the heads of the claims are like prolongation cost claim, which includes both on-site off-site overheads claim for the construction company. Extended stay cost are there. There can be extended stay cost based on it can be based on the conventional method, or last few years something which has really picked up is claims based on the methodology suggested in the Society of Construction Law Protocol. So that also, there can be prolongation cost and disruption cost claim can also be there. Then apart from that, there is a tendency amongst the contractor to build up claims on account of idling of equipment, plant and machinery, extended stay hire charges. There can be claims for the extended during the extended period on account of fuel, uncovered escalation on the fuel charges during the extended period. Then finance charges is something which is very typically we have seen in a lot of cases that this kind of claims are also there. Then there is an interest cost is there, and loss of profit, loss of opportunity is something which are very regularly built in as a good claim by the contractor, subject to terms and condition which is there in the contracts. And similarly, and that's the claim from the contractor side. Typically in the design build contract also, because you are supposed to finish your design within a specific time frame, and in case the design is not completed within the specific time frame, then there can also be a claim for extended stay of a design team design cost also. And suspension claim and termination claim can also be part of the contractor's claim, depending upon how the contract takes it. And as far as the employer's claims are concerned, they are largely constitute employers' claims are in the form of liquidated damages which they impose from time to time, and sometimes they also file a claim or counterclaim in the arbitration proceedings on account of defective work or carrying out maintenance activities for certain aspects of the projects, or abandoned work if they are getting it done to third parties. So these are the typically kind of claim which we generally see in the typical arbitrations related to construction contracts.
Yeah, very rightly said, Mr. Yogesh. And I think everyone would agree on this panel that more often than not, more than 50% of the construction contracts goes into dispute, whether it be, since, you have so many parties involved, maybe, as you said, maybe the design consultant, maybe the contractor, employer, anyone. So that brings me to David. I have a very basic but a very relevant question for you. How do you see the role of quantum and delay experts in these construction arbitrations?
Somya, thank you. Can you hear me properly?
Yeah.
And it's a pleasure to be doing something, working with MRP and Mayan. If I'm working with you on this, it means that you can't chase me on the other things that I'm working with MRP and Mayan on at the moment. And it's a delight to speak with L&T and Dentons, for whom I have the very highest regard. Look, a construction contract is really a contract to allocate risk. And the risk is in the construction of a complex asset, whether it is a house, which is a complex asset for a private individual, or a power station, which is a complex asset for most people. And that contract says, for a particular amount of time and money, this asset will be built and delivered. That is easy to say. There is a huge amount of risk involved in that, which is either anticipated or sort of comes from nowhere, like COVID. And the way in which that risk is then dealt with under the construction contract is either the time is adjusted, or the money is adjusted, or both are adjusted. And that, at a very simple level, is where the quantum and delay experts feed in. Now, that's easier said than done itself. The first role I see for quantum and delay experts is actually helping parties to understand what has happened on their project. So a client like Yogesh consults someone like Kirindeep because their project is late and over budget. Understanding why it's late and over budget involves quantum experts and programming experts like Mayan, because they need to come in and say, well, actually, one of the things that's happening to you here is, for example, the example that Yogesh gave, what's happening on fuel pricing, for example, and helping to tease things out, and so make the claim and identify, well, this has happened to our time, and this relates to this event, and this is how it all ties into the contract. There is that advisory role for them. But then in arbitrations itself, and sometimes this role is fulfilled by a different expert, in fact, sometimes the same. There's a range of experts, in my view. There are experts who are university academics who are fascinated about some particular chemical. And if you sit next to them at a dinner party, they will tell you about that particular chemical. And when they come to an arbitration as an expert, that's all they talk about. They don't know who's instructing them, what case there is, they just want to talk about it. In the middle of that, at the moment, I'm listening to evidence this week from two global experts on performance of power stations. And they're used to analyzing those power stations as experts, but principally their interest is how you build and make power stations perform. Quantum experts and programming experts take two things. They take evidence that is available to the parties in the tribunal that, in theory, we could deal with ourselves without the experts. If you take a very simple example, a house is ready to be built, the roof is ready to be put on, the roof isn't put on for 3 weeks. What's the cause of delay? It's putting the roof on. It's one event, that's it. But in fact, in the projects that we deal with, that Yogesh deals with, that Kirindeep deals with, they're too complex for that. The quantum is too complex for that. And so what we actually have is programming and quantum experts who take all this evidence. They know the way in which that evidence is properly analyzed and collated and whatever, and they process that for the tribunal. And in doing so, they occupy a role that in my experience is well known. The one thing they don't do, or the two things they don't do, and we'll come on to this, I think, is they don't give factual evidence, They don't say this is what happened on site. Sometimes they may be in a position sometimes to say, I visited site and I could see this. But generally, they don't give factual evidence. And the other thing that they don't do, and this is the mistake that some experts fall into, is give evidence on what the contract means. That's not the expert's job. That's the job for the tribunal. We say what the contract means with counsel. We just want the experts to say, this is what happened on the money, this is what happened on the time, and then whose risk that is, that's for the parties, for counsel and the tribunal. That's my view in a nutshell.
Yeah, that is very logical, and that would be that was really informative. And since we now realize the role of these experts, I would come to Kirindeep and ask you, in your experience, what are the typical shortfalls that you see in terms of documentation, because that plays a very important role. We all agree to that, when you work with Indian claimants in international construction disputes.
Thank you, Somya. Just before I answer that question, I just want to maybe for a second comment on what David said right at the end. And I agree 100%. Experts are not meant to comment on the contracts. But having said that, as counsel, as a solicitor, not at the arbitration, but outside of the arbitration, often the experts, people like Mayank and Rohit Singhal and Martin that I've worked with previously, they provide very good insight on contracts as well. For discussion's sake, I think that's very useful to have this discussion with the experts. But I agree completely with David that should be kept out of the arbitration arena. You don't want the experts being criticized for doing the lawyer's job. And quite often, if you have, and I think David would agree, if you have skillful QCs or counsel on the other side, they would probably exploit that in cross-examination. And you'd get caught up in that for a number of minutes, and that could then reduce the credibility of the witness. The tribunal would say, why are you doing the job of the lawyer, or why are you doing my job? So, yeah, agree there, David. But to answer your question, Somya, just one word, no disrespect, and this applies across the board to most clients. What are the typical shortfalls? The helicopter point would be lack of documentation. Okay, that is a typical shortfall in a lot of disputes. And I think a lot of lawyers would agree that when we come on board and when we advise the client, we find that there's a lot of documents missing, a lot of contemporaneous correspondence is not there. There's a lot of word of mouth. I said this, he said that, we had a gentleman's agreement. That is, I think in my years of practice, has always been the thing I hear from almost every construction client, whether it be Indian or otherwise. Another thing that is often missing is the lack of documentation when it comes to notices required under the construction contract, right? Notices for prolongation claim, notices for a variation claim, right? Often, in most form of contracts, the FIDIC form of contract, for example, other forms of contract, those notices are a condition precedent to any claims, and quite often that written notification is quite often missing. It need not be a formal notification, although that is ideal that you have a formal notification, but at least in the form of a minutes of meeting and an email, that sort of notification should be there, and that is often missing in a lot of construction claims. Insofar as quantum is concerned, right, very often what is missing is primary documents to support your plan. Someone like a quantum expert can come in and give you the method, try and do a quantification. But what happens quite often is the support for that quantification is sometimes missing because of the lack of primary documents. You may do a wonderful Excel spreadsheet, you may do a wonderful table mapping out what your damages are, but at the end of the day, you ask this question, this all looks really great, but where is the documentary support? Where's the primary documents? Where are the invoices? Where's the proof of payment? Right? Where even so much your accounts, where is it reflected in your accounts, etc., etc. So again, in a nutshell, that is what is usually lacking. Just to recap, there's a lack of documentation, contemporaneous correspondence, lack of notices that need to be issued in accordance with the construction contract, and also primary documents when it comes to quantum.
Okay, yeah, thank you so much. That you and David have helped to draw the line between the expertise of an expert and where a council should act. But at the same time, you emphasized on the requirement of proper documentation. So that directly brings me to Mayank. And I think you would be the perfect person to answer this question. What documentations are required when it comes to quantifying as they mentioned, prolongation cost as per the HCL protocol, things like that?
Thank you so much, Somya, and good morning to all. As rightly said by Mr. Kirindeep, that documentation is the biggest shortfall in all quantum claims. And whenever we appear as experts or quantum analysts, we find that certain documents are not available to quantify the claims and to substantiate the claim. So there are various heads of a quantum claim, which Mr. Yogesh has already elaborated. So when a project is in a prolongation claim and project is, and it is established that the prolongation is attributable to the customer, then contractors are required to produce certain documents to prove that these are the losses they have incurred, these are the additional costs that they have incurred during the extended stay period or in the delay period of the contract. So you see, there are various heads in which the claims are to be prepared. That is the manpower, additional cost incurred due to manpower, additional cost incurred on equipments, additional site overheads, head office overhead, loss of profit, escalation, financing cost. So if I go briefly on each of these, for a typical manpower claim, if we could establish the idling, that the work was totally idle and the manpower was totally idle, the equipments were totally idle in a particular period, the direct cost can be claimed. So how do we claim the direct cost? So the salary is paid to the people who were idle. So that may come from the ledger or audited book of accounts or SAP records of the contractor, which are good evidence enough. For equipments, if it is an owned equipment by the contractor owns the equipment, he must be booking depreciation in its book of accounts. Or companies like Larsen and Toubro have a system of internal hire charges. They have an equipment division which actually rents out the equipments to their various construction divisions. So those internal hire charges also are good evidence because they come from books of L&T. And if the equipments are hired from the outside parties of various vendors, then the service order or purchase order issued to the vendor is an evidence. But then we have to keep in mind that if an equipment is hired along with fuel and operator, so the fuel and operator cost has to be reduced from the claim because claim goes only for dry charges. And so fuel is say generally 30% of the hire charges of the equipment, standard wise, if we say. So then the important thing is the evidence of payment made. That is also very important, especially when the project is in dispute. So all these payments which are made to these vendors or service providers, the evidence has to be provided in various forms which are available. Then site overheads. Site overhead, definitely it's a recurring cost which happens every month-on-month basis. So it can come from the audited book of accounts of the contractor. Head office overhead, loss of profit, we have three formulas. The famous formulas which we can use, Hudson formula, Eichler formula, and Emden formula, which are accepted. Escalation of materials, steel, we are witnessing right now heavy escalation of steel due to in the market, so price rise on the steel. So escalation is one topic, so various indices can be used. Then there are financing charges, so interest on delayed payments. So if contract doesn't bar interest on delayed payments, contract doesn't prohibit to claim interest on delayed payments, interest on delayed payments can be claimed. Then due to extended stay, definitely the bank guarantees and the insurances need to be extended. So additional charges incurred, additional cost incurred on extension of these documents can be claimed. Then it may be required, the contractor may be required to pump in additional working capital, which was not envisaged. So again, along with evidences, the interest on working capital, which is booked into the accounts, additional working capital can be claimed. Then the other point is retention. So there's a retention which is deducted from every running bill of the contractor. Now these retention points, this retention money is paid after generally it is paid after the end of defect liability period, but due to extended state defect liability periods extend, so additional interest, that money which has not come to the contractor can be claimed, interest on retention. Then if a subcontractor has come up with extended stay claim or prolongation claim, it is contractor's duty to assess that claim, and if contractor feels the claim is justified, the claim can be passed on to the employer. So these are the typical documentation requirement which is required for a quantum claim to be established.
Thank you so much, Mayank. Now that we have realized the documents that are required to prove our claims, I think it brings me to Yogesh for the next question. Being a market participant in that sense, what are the challenges that you face in, in your arbitrations when you have to prove your case for prolongation cost or variations? And, end of the day, how do you overcome those?
So, as far as proving of claim is concerned, so largely not only that your internal documentation and substantiation document would depend would qualify that what are the kind of claim you are going to prove, but to my mind there is one more important thing typically in the construction arbitrations, that when you are going ahead with proving your claims, then I feel that the kind of constitution of an arbitral tribunal which you are having, that also plays an important role, because generally in a government contracts there is a requirement, they make you choose arbitrator from their own retired people, retired officers, or other PSU, similarly stated PSU. So those kind of clauses are there which pose a lot of challenges when it comes to arbitral tribunal. Legal department of the company and the people associated with the legal systems, their choice of arbitrator somewhere, because arbitration is a legal proceeding, so their choice of possible arbitrators are generally the retired judicial officers, high court judges, supreme court judges. So those kind of arbitral tribunal they look at. So the problem is that in case it is purely technical or bureaucratic tribunal, then they somewhere falter on the nitty-gritties of legal principles. And on the other hand, in case it is a projects and construction industry as such. So I feel that in case there is an arbitral tribunal which is a mix of both, then it's a balanced tribunal. And whatever claims, I mean the heads of claim, I have already told you that there are so many heads of the claim, including sometimes the contractor has to sometimes also claim the extension of time. Apart from all the financial claims. So if the extension of time has to come because of the delays which contractor claims that it is not because of the reason attributable to the contractor, then even you have to prove the extension of time. And then there is a requirement for delay analysis is there. Then there are different financial claims are there, cost claims are there. So you have to ensure that whatever, as a contractor, it is our duty and it is our obligation to ensure that whatever cost claim I'm raising, I have to support it with the valid documentation. Mayank has already talked about that what is the kind of data and evidence which can be brought in case of, claims have to be substantiated. So I feel that there are a lot of departments from the company which comes into the picture. Like Mayank said, that there can be overhead costs. Overhead can include the staff cost, it can include the plant and machinery cost, it can also include the financing cost, bank guarantee charges, and all those. So within a claimant company, the HR department has to pitch in. They have to provide certain data to support the claims. The finance department has to do something. The plant and machinery department has to do something. So everybody has to pitch in and see that these claims are there. So the problem happens when you have claims which is very, very industry specific, and there is a judicial member who doesn't understand all these things specifically. So then there is a challenge which are there. And similarly, in case your claim is, let us say, for it is basically you have a claim for extension of time. In the extension of time claim of kind of situation, first of all, you need to establish your causation. So the challenges which we see coming out from the employer generally in these kind of arbitration proceedings is they are saying that first you need to establish the causation. Cause and effect relationship has to be established, and then you have to see that the limitation is another point, which is which poses a great challenge to typical claims in the arbitration matters, because there is a tendency amongst the contractor to not to disturb the project progress by invoking the arbitration or dispute resolution clause while the project is on. So they tend to initiate the arbitration proceedings only after the project is over or towards the fag end of the project. Though the contract provides that as soon as there is a dispute, you should invoke your arbitration and the parties will continue to perform their respective obligations. So these are the challenges which we face. And in India, I feel the construction as an industry and construction as a domain is still to see a lot of development. Unlike West, where there is a codified law as far as the construction law is concerned, there is nothing of that sort in India. So everything is dependent on the general principle of contract law, which is reciprocal obligation and the damages rising therefrom. So I feel that going forward there is a need to nurture the construction claim arbitrations and construction industries as a specific domain in itself to bring in more clarity, more definitiveness in the construction claims and construction industry.
Yeah, very rightly said, Yogesh. The jurisprudence in India regarding construction disputes is yet not developed, and that poses many hurdles when it comes to resolution of these disputes. And now that we have spoken about, the requirement of documentation in terms of quantification of the claims and the, as you rightly pointed out, towards the importance of a constitution of a proper tribunal with a combination of legal and technical experts, I think now I come to David with my next question regarding the role of a fact witness, and why is it mandatory, in your opinion, to have such witnesses in construction arbitration specifically?
Well, Somya, the first point is, and it's implicit in your question, why aren't documents enough? And sometimes they can be. What fact witnesses should not do is simply narrate every single email and letter that they ever wrote. And sometimes you see witness statements that are like that, with a witness saying, I wrote this and he wrote that, and I wrote this and she wrote that, and I wrote this. There is no point in that. There is an enormous amount of material that we have, which we can simply do from the documents, and that's enough. I think there are three areas where fact witnesses are relevant, however. The first is that there are some issues that arise in construction disputes where you technically have to have a fact witness to prove your case. And that is, for example, if some sort of estoppel is alleged, or if there is some reliance asserted, somebody has to say, this woman said this to me and I relied on it. So you have to have fact evidence of that. An expert can't do that. So that is a technical requirement for proving the case. The next point, and I tend to use this when I'm counsel with at least one witness. People think in stories. People like stories. And for any complex project, it's difficult to sit down with the EPC contract, the subcontracts, the concession agreement, the financing agreements, the specifications, to read them and to come away after 2 days of reading and think, oh, I know what that's about. You still haven't got a clue. So there's always an use for the project manager or somebody similar to say, look, this is a project for the construction of 250 megawatt combined cycle power station in Chennai. Fine. Okay, I know, I now know what we're building. And this is what happened, and this is what went wrong. And at that point, the fact witness gives you the shape of what happened. And I think that actually is useful in terms of educating the tribunal, educating the other side, just telling the story. So there's that value. The third point is there are some things which, in my experience, you can't get from the documents, and even the experts can't get from the documents, which are specific points of detail, and where, in fact, what you have to do is you have to take the documentary evidence and the oral evidence, the oral factual evidence, and fit them together to make the complete picture so that the expert can opine. Now, 2 examples. It may be that a variation is being claimed and it's a variation for an alleged oral instruction. So that's fine. You need evidence of the oral instruction. We were doing X, Y, and Z, and so came along and instructed us to do A instead. The other area that is necessary in my experience is sometimes there is detail in relation to quantum or time or both. Which you simply can't get from the documents, but which a fact witness can fill in. And this is where it gets very, very, very detailed in terms of the way in which the experts work with the client team. And let's take a simple example of craneage. You may have an extension of time that's claimed, and you may have cost that's claimed for the hire of a crane. And everyone may say, okay, we can see that it's a variation, and that necessitated the hire of a crane. Someone may say, but hold on, the crane is hired and the delay that is claimed is 10 days. And in fact, the expert evidence is that you only needed the crane for 5 days. Okay, at that point, the quantum expert and the programming expert are saying, look, this just looks too much. If you then get a fact witness who comes along and says, well, hold on, I can tell you from my own diaries or site diaries or my own notes, we had high winds for 5 days. So we put the crane up for 2 days. We had high winds for 5 days, which meant we couldn't use the crane. We put the crane back up for 3 days and we finished it. Then you have the story from the documents and from the fact witness. Then it's for the tribunal to work out who's at risk for the 5 days of excess hire. But that's the only way, with the use of that fact witness, that you can actually put the whole story together. And where that's important, and where that's really important in terms of working with experienced expert witnesses, is inexperienced expert witnesses will actually find that out. But they don't put it in their report, and they don't have a witness statement to support it. And so sometimes on cross-examination, someone says, well, that's too long. And they go, oh, yeah, but there were the high winds. Where are the high winds referred to? And the answer is nowhere. And that gives the tribunal a problem. Where it's important is the expert digs in and goes, hold on, why did you have this craneage for 10 days rather than 5 days? Says the fact witness, because we had high winds for 5 days. That means you have to have 2 things that are done by the experienced expert witness. One, they refer to that in their report as their explanation. And secondly, Kirindeep goes away and puts into a witness statement somewhere the witness evidence of the 5 days of high winds. And at that point, you stitch everything together.
Yeah, that is completely true. And, I would just add one thing to that I guess the fact witness is able to go into such details and tell about things which are not documented properly, because there is an emotional connection, right, with the project for that fact witness. It's their baby. So, that actually plays well for the tribunal as well.
Yes.
Yeah.
Yes.
So, yeah. So, Kirindeep, I have my next question for you. since we are talking about the arbitration procedure, and like the life cycle of a construction project can be extended for so many reasons, and so what happens if the claimant, or say the respondent, has not included a claim head in their request for arbitration, or either forgot to submit it as a head in their terms of reference? What are the options available? Can it be raised at the pleading stage later?
Good question, Somya. Again, I just because what David said is very, very interesting. Just one point on that. I mean, I would think not too many factual witnesses. I'm sure David would be on that they wouldn't contradict each other. So when you're putting forward factual witnesses, make sure they all are covering separate areas and they don't overlap each other. Then you get a tendency of them contradicting each other, and then you're in a big mess. So just to maybe raise that for discussion later. But yeah, Somya, happens. You mentioned terms of reference. So if you're dealing with an ICC arbitration where there are terms of reference, and you have omitted that head of claim from your terms of reference, and you wish to include it at the pleading stage, you may have to amend your terms of reference. And it depends. It depends on is it a really distinct claim? Is it possible for you to link that claim into any of the matters you have mentioned in the terms of reference? If you are not able to, then there are provisions within the ICC rules for you to amend your terms of reference. But having said that, it needs to be done early, right? I have a situation where it was the other way around, where the head was in the terms of reference. But when we took over as counsel, we realized, as solicitors and counsel as well, we realized that certain heads of claim in the terms of reference were not in the pleadings, right? And we then applied to amend our pleadings literally on the eve, literally almost like 2 or 3 weeks before the arbitration hearing, and the arbitration had already been vacated once. And the tribunal basically said it's too late. You've not included that in your pleadings. It's witnesses are ready, tribunal is ready. If we vacate this, we don't know when everyone's going to be ready, and they didn't allow that amendment, which then basically forced us to bring a separate arbitration on those things. So it is possible in an ICC arbitration. I think you would have to do it early enough, and then you'd have to probably apply to amend the terms of reference as well before inserting it into the pleading stage. Now, if you have an ad hoc arbitration or you have a non-ICC arbitration, several institutions have arbitration rules that don't have terms of reference. Then I don't think it's very difficult. You can apply to amend your pleadings, but again, you have to do it early enough. You can't do it so late, like on the eve of the arbitration hearing, where the other party doesn't have a chance to file their amended pleadings in response. There may be a requirement for supplementary witness statements, a supplementary expert statement. So it is possible, but it has to be done early enough for you to have that head of claim covered within the arbitration. That is, I don't think I have anything else to add to that.
Okay.
So,
okay.
Yeah, unless you have any questions. So
no, I think that was pretty much clear, like as long as we follow the procedure and raise the claims earliest as possible, right. The tribunal should be, in a situation to allow such claims. Yeah. Correct. I mean, there are even situations where it's a very important claim, for example, and I've seen tribunals actually vacate the hearing because tribunals don't want to be caught out for breach of natural justice. Yes. If you don't allow the claim, the award could be set aside, etc., etc. But that can't go on forever. Maybe once, But with 2 or 3 times, I think the tribunal has the right to say, look, we have to balance natural justice. We have to balance efficiency, cost, etc., etc. So, yeah, that's my 2 cents worth. Thank you. Thank you. Mayank, I have my next question for you regarding, if you can tell us about the difference between time and task-related costs.
A task-related cost is directly related to the task which was stopped or which was not happening or losses due to task, whereas time-related costs are generally the recurring costs. Just to elaborate a bit, like as I explained in answer to your previous question, that there were heads, manpower, equipment, subcontractor claim. These are task-related claims. So as I said, that if we could establish that there was a total idling of manpower or equipment, so when the idling was actually happening, you need to claim for that period only. So it's a task-related claim. Or if there is a loss of productivity, that means there are disruptions. There are no specific delays where the work was stopped, but there is a loss of productivity. So you can come up with a loss of productivity claims or disruption analysis, which is very well guided by Society of Construction Law Protocol. There are various methods mentioned in it. So these are the task-related claims, where the cost is occurring on a periodic basis, like site overheads, that is a monthly cost that contractor is incurring, or head office overhead, loss of profits, interest due to delay. So that is again, it's a time-related cost. Time is extending, so the interest is going up. So these are the time-related costs. So these are the various heads can be divided into these two. We can say that direct manpower, equipment, subcontractor are task-related costs, which are specified to the task and specific delays. And in fact, for task-related costs, CL protocol says that we are not required to claim for the extended stay period. In fact, the claim should be for the period when the delay is actually occurring. It may be within the contractual timelines. And time-related cost is definitely the extended stay is related to the extended stay of the contractor. So these are site overhead, head office overhead, loss of profit, interest are time-related cost.
Okay, clear enough. That was good. Yogesh, I have my next question for you. I have these questions from the participants, and I guess maybe you can answer this from your experience. When a contractor is making a cost claim for extension of time, as you was discussing earlier, what are the common errors that he makes in terms of substantiation of those claims, extension of time claims?
Extension of time, the most important things, as Kirindeep also pointed out, and also pointed out by Mayank also. So when you are making an extension of time, most important thing is to establish a cause and effect relationship. So the most critical problem which I have also experienced as my career as a infrastructure lawyer is that the contemporaneous correspondence is something which is missing at a relevant point of time. So there is a need to do a contract management and need advice. The expert advice is required right from the beginning of the contract, because most of the contract nowadays they have a notification clauses which requires certain notification to be given in a particular time frame. So if those notices are not there in order in time and they are not on record, then these kind of defaults in maintaining a contemporaneous correspondence and notification during the project progress can actually hamper, and they can actually affect your entitlement for extension of time for any other kind of a claim at a later stage. Like in FIDIC, there is a clause 20.1 is there, which talks about FIDIC 99 edition. There is a clause 20.1 which talks about various compliances to be made for maintainability and sustainability of your claim. So that is something which is very important. In fact, I suggest that there has to be a dedicated contract manager, or there is an external help which is there during the progress of the project, because invariably 90% of the construction project goes for a toss and they go for the extended period. So it is from my side, it is advisable to have a dedicated contract person who can actually work on, and they can concentrate their talent and energy on maintaining these kind of correspondences, which should not affect or which should not compromise your claim at a later stage.
Yes, very rightly said. Because given the very nature of it, construction contracts, they do get extended at all times. And documents are such an important part of the whole process. But at the time of writing the agreement, I guess we all would agree that everything is almost acceptable to both the parties. They don't realize it until the end of the project when disputes arise. So it's very important that you involve experts, technical as well as legal during the very initial stages, so that there should be more effort towards dispute avoidance than dispute maintenance. I would say that. So I have my next question for you, David. Given your global experience, I guess you would be the best person to answer this question. You have done so many arbitrations governed under the Indian law. In your experience, how do you find Indian construction law vis-a-vis English construction law?
Give it some.
Somebody had to speak on mute, and it had to be me. I think this goes back to a point that Yogesh made earlier on, that you picked up, Somya, about as to there sort of not being specific Indian construction jurisprudence, in contrast to some of the jurisprudence that we've got in England. But in fact, English jurisprudence, a lot of our specific construction law jurisprudence is in relation to things like pay when paid clauses, and the requirement for adjudication and those sort of provisions. A lot of English construction law is contract law. And so to that extent, what Yogesh identified is no different. One of the reasons I think I'm able to do Indian disputes is because of the Indian Contract Act that takes contract law down to late 1870s, and it's exactly the contract law that I'm familiar with. And then Indian law has tended to follow English law or vice versa. And so English law, Indian law, the law of Singapore, the law of New South Wales, they're all quite useful. And you find that either something isn't addressed in one of those laws, but you can borrow from one of the others, or on things like limitations of liability and exclusions of liability, I very often find that my sort of colleagues, I will end up saying, well, what's the authority for this? And well, you don't use the English authority, here's the Indian authority in the Supreme Court. And oh, okay, that's exactly the same thing. So that works. I think that the differences that I see are this. First of all, standard form contracts. And they're different standard form contracts. They're very often imposed by the railway authority or the various energy authorities or whoever. And they are sometimes very idiosyncratic and very, very employer focused. And so that can be an issue for me. Whereas if it's a FIDIC form of contract, you can operate a FIDIC form of contract perfectly well in India. And then the other thing that I've seen developing over the last, I think I started doing India related work 30 years ago now, is the development of the Indian construction law profession, which I think I've seen over the last 30 years. And so Mayan was founded less than 30 years ago, but is there as an Indian expert, quantum programming, everything. And that helps in terms of their understanding of the industry, the sector, that sort of thing. The Indian Society of Construction Law is another organization. Society of Construction Law internationally is significant. The Indian Society of Construction Law is doing tremendous things in India. And so I think that's one of the things that I've seen as a difference that is maybe disappearing, is whereas 20 years ago I was working with general litigators who came to me as a construction specialist, but they were general Indian litigators. Now I'm working with Indian construction law specialists in my experience. But I'll tell you, it is far easier and it is far less idiosyncratic than doing, as you know, than doing construction law in the Middle East, where some of the legal principles are really profoundly different to Indian law and English law. And as soon as you're dealing with a Middle Eastern, with a contract based in the Emirates or Oman or somewhere like that, that becomes a completely different exercise, which isn't such an issue for work in India.
Yeah, I would completely agree with that on you regarding the Middle Eastern laws. And yeah, that's a good thing that, Indian law is, has picked up the pace and is developing in every sense. That's good for every one of us. And I have another question for you, Kirindeep. This is a little detailed. You know how tenderers would provide the soil investigation report, in the bidding phase, and the bidders would highly rely on that data while putting up their quotes and preparing their baseline program. But, when the contract is awarded, and then they realize that, the data available to them is completely different from the ground reality. So what now?
Okay. Maybe let me start off with a Singapore case, and I think that's quite a good follow-up from what David said, whether or not our principles are similar to English law principles or Indian law principles on this issue. A very, very interesting and I think a very relevant question, Somya, on this. Now, the case that we had in Singapore, a landmark decision on this issue is a case called resource piling and geospecs. Now, in that case, this is exactly what happened. The piling contractor won the tender, proceeded to do the works, and then encountered unforeseen site conditions. He went on to do the work, but incurred much more cost than originally envisaged under the tender. Because of different piling that was required, more micropiles, etc., all of those technical issues, it bumped up the cost, I think, by as much as almost 50 to 60% of what was envisaged under the original contract. So variation claims were not allowed because the owner pointed to the contract and said, well, those borehole logs are for your information only. You are required to do your own investigation. And all the usual caveats that you find in a lot of tender documents about not accepting any liability for those borehole logs, all were present in the contract. So the piling subcontractor could not proceed against the owner. Piling contractor could not proceed against the owner. And what they proceeded to do was sue the borehole log contractor in tort, right, for breach of their duty of care. In Singapore, we have 3 stages to satisfy a duty of care. Well, it's a threshold stage, and it's quite similar to the English position, but we have a 3-stage or 2.5-stage test. First stage is the threshold stage of foreseeability. The court found that there was foreseeability. It is foreseeable for the borehole log contractor to realize that if it does it work negligently, it will affect the contractor, right? They overcame that test. But the other 2 tests, one was proximity and the other policy considerations. And that's where they did not succeed because the Court of Appeal held that there's no proximity here. You had a contract with the owner, which you could have taken, which you could have amended, which you could have inserted, or you could have done your own. You took on the risk. Basically, the court said you took on the risk. The contract was there. It's clear as daylight. You had a recourse against the owner, but you agreed to take on the risk. So there's no proximity. I cannot allow your claim in tort. And that was also a policy consideration because the court said that, look, it will open the floodgates. It will open the floodgates to such claims. We can't allow that. Please be careful when you sign a contract. Please be careful when you put in your tender. Now, that answers our question. If contractors are going to enter into such a contract and later on discover unforeseen site conditions, it's going to be very difficult to backtrack. So you can do one of 2 things. First one is not easy, and as David has mentioned, a lot of contracts are very employer-centered. So you probably encounter a contract which says that when you submit your tender, we do not accept changes to our standard forms. That will be, your tender will be thrown out, all right? That leaves you possibly with option 2. Option 2 would be to submit your tender and maybe insert certain conditions in there or caveats in there, and hopefully that can get through the cracks and it could protect your position later on. A third point, which is quite interesting, sorry, I mentioned 2, but maybe if it does come to the point where you have done number 1, you've not amended the contract, you've not included caveats, and you do encounter that situation. One possibility, maybe it's quite a normal argument, is I don't know whether you can bring a claim against the owner for misrepresentation. You misrepresented the soil conditions, this is false, this was negligent, etc., etc. I've seen those arguments run before, but I've not seen the outcome of those arguments because the matter was settled, right? So I can't comment on that. So that is my views. Be careful. Amend the contract if you can. If not, think carefully about your tender and what you're going to put in there. If you do encounter those unforeseen conditions, how would you protect yourself within the tender document itself?
Yes, being careful is very important, and the contractor should realize that at the very initial stage. Mayank, very quickly, I would like you to answer one of my last questions. What are the documentations required to establish quantum of variations? If you can just tell me very briefly.
Yeah, so basically to establish quantum of variation, you require two things: quantity and rate. Once the variation is established that it's a variation, then what is the quantities we are talking about? So quantities can be derived from the document, what was the original drawing and what is the as-built drawing. Rate, if it is a BOQ based contract, fine. Rate is available in BOQ, fine. If rate is not available in BOQ, the purchase orders are available with the contractor from where he has purchased the material, or service order is available. For some reason, if rates are not available there also, then there are various rate analysis available with PWD, CPWD, MORTH data book. So rates can be established from there. So once we have rate and quantity, so with evidences, then the quantum is established. Yes, the evidence of payment is also required, that okay, this amount has been paid or this cost has been incurred. So this is how you actually establish the quantum of variation.
Okay, thank you. I think there's one last question that I'll take regarding the essential details required to establish loss of head office overheads claim. So from a construction lawyer's perspective, I would say, the onus is always on the contractor to prove that the actual loss has been suffered. For that, the contractor must be able to show that the anticipated turnover was adversely affected by the delay in the project, and that he was prevented from earning a contribution to overheads as a result of this delay. And definitely the actual overhead cost should be reasonable. First of all, I would like, as we all know, that the head office overheads are categorized into two subcategories: dedicated overheads and unabsorbed overheads. Firstly, the contractor should try to, maintain proper documentation so that they're able to prove everything through records that they have already. And if that does not suffice, then as already Mayank mentioned, we have the three famous formulas, right? Hudson and Emden's and the Edgeley's formula, which would help us to determine the quantum of such a claim. So I think we are already post our dedicated time. I would like to thank everyone for joining this session. And it was really very informative and very engaging the way that you all answered. And I guess the audience will have definitely found it very informative. So thank you, everyone, once again. Have a nice day. Stay safe.
Thank you so much. Thank you all.
Thank you so much.
And thank you, Somya. Thank you.